Good day, everybody. I guess I'm live now. Yeah, I'm live. There we go. Welcome to the Entheogenic Esquire podcast. This is an impromptu live session today. I'm still working on getting OBS, my kind of streaming editing software, reconciled with YouTube. So I'm not going to have the screen share function today. However, I have my email in the description if you would like a copy of the outline that I created for this episode, for this live stream. I'd be more than happy to send you a copy. Just reach out and let me know. That's no problem. And I will hopefully soon have the OBS integrated into my YouTube stream here. So that way I can do lives with share screen and stuff like that. And quite frankly, ladies and gentlemen, if this goes well, I'll probably switch to doing a predominantly live format with some of my 7 to 10 minute shorter videos kind of, put in between there to keep the content flowing. It looks like I have somebody in here already. Joni. Hey, Joni. Very nice to see you here. Glad you could join us. I'm going to hop in the law here in just a second. So as the, well, let me make one more just kind of channel announcement now. Yeah, very nice to have you here, Joni. Yeah, absolutely. I'm almost to 500 subscribers. And I've only been posting for about 10 days and I've gotten incredible comments. Like, thank y'all so much for real. I tell people all the time that it's like, and this has happened in other endeavors I've had, like when people make good comments and say they benefit from your work, stuff like that. It's like on those days where, you don't have the most like motivation and drive to like, I guess, do it for me or do it because I enjoy it, passionate about it. Like thinking about those nice comments and people like, hey, I'm getting a lot of benefit from your work. That many days gives me that extra drive that I need to like get up and really give it that effort. So I really can't thank y'all enough from the bottom of my heart. We are here in the mountains trying to prepare for the impending ice storm. So I just want to make that caveat here. Hey, Linda, how you doing? Very nice to see you here. So yeah, just with that caveat, if weather goes crazy, internet goes out, y'all know I'll be okay. But the live stream might clunk out. So just want to throw it out there before we get too deep into this. And so again, thank y'all for being here. So today we're going to be talking about defamation law. As I'm sure pretty much anyone who's going to hop into this live chat here is aware, Turning Point USA via an attorney in Indiana has been sending cease and desist letters to Wolves and Finance, who is an accountant content creator, great content creator. Go check him out, Wolves and Finance, who's been doing some pretty incredible work and investigation around TPUSA, their nonprofit, their tax returns, the vendors, the outside companies they're dealing with, and has been doing so again, just some really good journalistic reporting work. And so he was the first one to get a cease and desist letter. And we'll talk in just a second about what is a cease and desist letter, what do they do, things of that nature. And then Candace got one also. So Candace Owens also received a letter. Now, one important distinction here, and I'm pretty sure most people probably pick this up, but just to kind of review, is that Candace's letter was mostly based on a contract. So the contract that she apparently had with TPUSA many years ago, they're alleging that this clause that prevented her from saying damaging or disparaging comments survived the contract for a number of years. And that is true. That's a valid contractual thing, just so you know. Those things can happen. And so that's really how they kind of addressed her, was through the contractual angle versus Wolves and Finance, who they obviously never had a contract with that we're aware of anyways, went straight for the defamation angle there. And so, but essentially what we're looking at is the same thing, right? Whether they're going after, hey, how you doing, Tally? Whether they're going after Candace, under the contract for her statements that she made, or whether it's defamation, Wolves and Finance, essentially the same, that, hey, there are these damaging, disparaging things that y'all have been saying through the course of your investigation, publishing them on YouTube and these other platforms, right? And so that's really forming the basis of these legal claims. So we're not going to go into the contractual stuff with Candace, right? We're really going to focus on the underlying defamation aspect of this. The impetus for this actual live stream is just me watching a lot of the videos, content creators and stuff talking about these letters. Not that they've ever said anything like necessarily wrong or incorrect or led anybody, but there's some important, let me say this real quick, is that defamation law is very dense and it can get very conceptually tough, just because there's a lot of nuance in it. And what essentially defamation law is, which, just so you know, it's a mix of two components. It's mostly driven by state law, but obviously because we have a right to free speech under the First Amendment, state law must yield to constitutional principles, meaning that state laws, what we call the common law, would provide a redress for people, basically laws where they could go to court and sue another person in that state for making defamatory statements that injured their reputation. They could go and sue those people and recover damages for the loss in reputation or damage to reputation. Okay. And so where we see the Constitution come in on this is obviously that, hey, well, sure, you can sue people in that state, but what if you're infringing upon their right to free speech, meaning that your lawsuit could prevent or punish someone from otherwise exercising a constitutional right, and we can't have that, right? So that's kind of the tension that we see in defamation law, is the state wanting to give redress, the ability for redress to its citizens, versus the federal Constitution, which has guaranteed all of us the right to free speech. So state law, which governs defamation law, varies state by state, but there's always that constitutional standard that they cannot go below, meaning that the state laws have to provide a specific and certain level of protection for people to speak freely. If they do that, then they're free to provide whatever other redress or specific procedural hoops or whatever they want beyond that. But there is a constitutional core that must be protected. And so when we're looking at defamation law, the way it comes out is resolving those two tensions. And periodically, the Supreme Court has to step up and, rule on a case that, from time to time will require states to adjust their laws to make sure that it's congruent with the constitutional protections that are otherwise provided to people under the First Amendment. Okay, so that's kind of where we get the defamation law. So, and I want to say that to say this is that today my discussion of defamation law is not legal advice. Let me put that out there. This is not legal advice, nor should it be construed to be legal advice. This is simply an academic general discussion of defamation law. Now, I'm licensed in Texas. I practice in courts all over the country, state and federal, but primarily licensed in Texas. And so I pulled out my Texas treatise book here, right, that talks all about Texas defamation law. Obviously in there is the constitutional aspects of it too. So I pulled a lot of material from this. And so with that being said, I have to have the caveat that some of the stuff I'm speaking of could be kind of specific to Texas, but again, all state defamation law has this constitutional core. And so I did my best making my outline last night to make sure that my points are really based primarily in the constitutional aspect. Inherently, there's going to be some Texas stuff bleeding into here. I'll try to make that clear as I'm discussing, hey, this is Texas specific. Now, and again, just because it's Texas specific does not mean necessarily that that's not also applicable in your state. Okay. Again, there's this common constitutional core, and I've tried to keep my lesson today basically anchored to that, more or less. So because the U.S. constitutional core applies everywhere, in every state. Joni, oh, thank you. Yeah, I hope y'all get something out of this. Like I say, I did it, for people who aren't content creators, just so that way you'll have an idea when you're looking at stuff hey, they might be, that might be bad. That looks like a light read, Pete. Hey, just so y'all know, these books, these treatise books are, I think I paid $800 for this book 3 or 4 years ago. They obviously every year they have updates, stuff like that. This is actually, and I gotta admit, this is I think 2 or 3 years old. But yeah, it's not a light read. They're great books. They're great books for a person who's a litigator or practitioner. They're incredible. You can pick up these books and pretty much get filled in on the fundamentals and basics you need to know to litigate in these different areas. So yeah, this is a great companion, and I hope that the stuff I pull out today for this lesson will be beneficial for everybody. And then, obviously I want people in the community to be aware when they're looking at this stuff. exactly what they're looking at. Yeah, it's my first live. Yeah, Pete, it's my first live, and so if this goes well, I'm gonna try to do this more often. I'm really kind of liking this, to be quite honest. My computer, being a litigator attorney, I've never bought a computer to have like all these fancy graphic cards and big upload speeds. I've been very minimalist. Like literally, I just need a good word processor, get on the internet, do some research. That's about it. So I'm having to upgrade my computer, and I hope to have a new computer this week. We're working on getting our internet upgraded, and then I have video going in downstairs. And so hopefully within 2 weeks or a month, I'll be fully up and operational, fully professional. I'll probably be working out some tweaks still, but moving towards being a very professional outfit. Yeah, it will go well. Thank you, Linda. I appreciate that. I've had a lot of really good, favorable comments, y'all. I do appreciate it. I have made a firm commitment to being apolitical. My allegiance lies with the Constitution. It pretty much always has. And here to just shoot you straight. I don't have any Republican left or right agenda at all. I think, as a matter of fact, that's where we lose. So this channel is going to be geared towards really trying to remain centered and objective and really tethered to the Constitution when we're covering like law, stuff like that. Okay. Lives are great. I feel there is a good mojo for community. I do too. Yeah, no, I feel good. This has been a great community. I've been, just real quick, I'll fill y'all in. I've been kind of just regular person sitting here watching a lot of these content creators like Candace, Barron, Coach Colin, just y'all probably know who I'm talking about. And so, yeah, to be able to jump in and kind of fitting in so far has been really good. And obviously, I don't want to step on anyone's toes. I think I'm kind of crafting a niche for me in this, and I think that'll evolve over time. But I hope that I'm really providing value. That's important for me. And so here we are today talking about defamation law. So thank y'all again. Yeah, you're my kind of people too, Joni. Yeah, thank you for being here. You're the first person to ever attend one of my live streams. So here we go. And again, let me just, with my disclaimer, this is not legal advice. And, because for one, I don't know anyone's specific situation, so I can't give legal advice without knowing exactly what you're facing. But other than that, just general educational content here. So again, and this revolves around the cease and desist letters that TPUSA sent. I guess it was about a week or so ago. I talked already about the defamation law is the state common law versus the Constitution, First Amendment rights. What we see in defamation law is really a reflection between those two competing interests. Let's see. Okay, so the three main points that I'm going to really talk about today in defamation law are, one, I'm going to go over the elements, the general elements of a defamation claim, but then we want to talk about like what is an actual actionable statement in defamation, right? What constitutes something that is defamatory in nature and could serve as the basis for someone to assert a defamation claim. So we're going to knock that out because and I'll just real quick say this is that I think a lot of people are under the mistaken impression that you can simply just say, hey, this is my opinion, or hey, allegedly, and that just takes care of everything. Certainly it can in some scenarios, but as we'll see today, we really need to do some deeper thinking than just relying on that, in my opinion. Then we're going to look at what is the difference between a private plaintiff, a public figure, a public official, a limited purpose public figure, and an all-purpose public figure, because that assessment determines what level of culpability a defamation plaintiff must prove, whether it's negligence, whether it's actual malice, reckless disregard, these things, right? And then that fits right into the next point we're going to discuss is what is a matter of public concern, because whether or not a statement involves a matter of public concern also affects the level of culpability required by a defamation plaintiff to prove. Okay, so we're really going to look at those three concepts because they're very important and they really determine what kind of case a plaintiff or potentially a defamation defendant might be looking at. So why this matters, and I just have this written down here, but yeah, you want to be able to look and know whether certain statements or allegations allegations are even going to be actionable or not, and if so, to what degree. And then, we're going to look at whether or not TPUSA is a public figure, a private plaintiff. What category does TPUSA fit in there? Because obviously that'll mean, what level of culpability would they have to prove if they were going to court against one of us. And then we're also going to look at these issues of Charlie Kirk's unaliving, of TPUSA investigation. Are these matters of public concern? Because again, that also will reflect on the kind of case that TPUSA would have to prove in order to actually hold one of us liable, accountable on these claims. Okay. Before I get too far into that, there were two things I wanted to discuss. And one is this, and I think this will be very important for people to understand. Someone who republishes, yeah, you've heard the caveat allegedly so much this past month. One of my favorite content creators, 5149 James Lee, it's like he's got like merch that says allegedly, and he like finished it. He's done a really good job at like fitting it into his content and making it pretty comedic, So hopefully James will see this and get a little bit out of this. And James, feel free to ever contact me if you ever want to talk or have about this or anything, for sure. But yeah, so someone who republishes a defamatory statement can be held just as liable as the original republisher. Okay, so ladies and gentlemen, when you're seeing on X or YouTube or these social media platforms, whenever you are reposting stuff that people have posted, or anytime you're repeating something that is defamatory, you potentially could be held just as liable as the original publisher of that statement. It doesn't matter where the defamatory statement or content emanated from, essentially, is what I'm saying there. So hopefully that makes sense. So just be aware of that. I want to talk real quick about anti-SLAPP statutes. So what does that mean? So against strategic lawsuits against public participation. So what this is, and these are state laws, okay? And as far as I know, every state has one of these, but these are state laws designed to give people like me or Wolves in Finance, smaller citizens who are out there speaking consistent with their First Amendment liberties, an avenue to get a very quick and cheap and efficient dismissal of a defamation suit, right? So if someone who's big, powerful TPUSA, this is all just hypothetical conjecture, by the way, but if some big, powerful TPUSA sues Wolves in Finance, I don't know his financial situation, but from what I took from his video, he's not super wealthy or have tons of attorney. Oh, you like that, Linda, about the republishing? Yeah, I figured y'all would like to know that. Yeah. But yeah, so the SLAPP statutes are designed to help protect people like Wolves in Finance, who, again, this is just a general opinion from what I've seen, who is otherwise engaging in protecting First Amendment activity from getting beat up in the courtroom and having his speech, his free speech rights trampled on just because you don't have enough money to pay a lawyer. Because that's essentially what can happen, right? Is that people can otherwise be speaking congruent with their First Amendment liberties, but because they don't have the money or the resources to hire the lawyers to defend them, someone like TPUSA could literally prevent them from exercising their religious freedom just because they have money and the other party doesn't. And so the anti-SLAPP statutes are meant to provide a very quick means through, without having to do a bunch of discovery or a bunch of litigation, provide a very quick and efficient means for an individual who receives a cease and desist letter, or who's been sued, might I say, to show up, file a motion to dismiss, and if the speech fits within the categories elucidated in these SLAPP statutes or in the constitutional jurisprudence, then they can easily get it in proper cases, get it easily dismissed without having to spend $100,000, $200,000 in attorney fees. Okay. And so the other night on Barron's live stream, he was talking about the letter to Wolves in Finance and the fact that they didn't even include like direct quotations and stuff like that. Okay. Because anti-SLAPP statutes normally require very detailed notice be given. And not only that, it also requires that not only, and so that's where the cease and desist letter comes from, right? These statutes require that before a party or a plaintiff like TPUSA can either collect damages or in some instances collect like punitive damages, they must give notice, very detailed notice, and a chance 30 to 60 days, sometimes longer, for that individual to retract, correct, and in some instances even apologize in order to avoid litigation. So if they don't have a chance, if they're not notified and get an opportunity to cure the defamatory content alleged, then under most, as far as I know, maybe all slap statutes, someone like TPUSA. Hey, Elena, very nice to see you here. Thank you very much. Yeah, so it would just, TPUSA wouldn't be able to collect damages and or punitive damages or, exemplary damages if they don't follow the notice and cure protocols, the anti-slap statute. So for instance, in Wolves and Finance situation, I don't have it in front of me, but I'm almost sure Arizona will have some type of anti-slap statute. And so TPUSA would need to comply with whatever that statute requires as far as notice and cure provisions before they file suit and can collect damages. And Barron mentioned the other night, and maybe he's right too, is that maybe there's some slap statutes where you can't even file the lawsuit, meaning you wouldn't even have jurisdiction. So there's probably some of those too. I know like in Texas, it's really just relates to damages, but it's one of those things where, well, hell, if I can't collect damages or, punitive damages, appropriate damages, why would I even file a lawsuit? So that's why he was talking about the notice and the defects essentially in notice to Wolves and Finance, because there were no direct quotations. And you see in his video the result of that, right? The man's literally having to try to guess what it was that he said that was, offensive to them. And so slap statutes don't want that. They want people to have a definite idea, understanding of what it was that's defamatory, what it was, why it's defamatory, and give them ample opportunity, 30, 60 days to cure that default if they agree that. And so when we see with Wolves and Finance, right, he's amenable to correcting and stuff. So based upon Wolves of Finance attitude and the content, it's my opinion that they would have a very hard time suing him. I don't think that, and we'll get to this in a minute, but the burden of proof, they have to show actual malice, and just his attitude and stuff like that. I don't think they're going to be able to do that. And we'll talk a little bit more about that in a second. But yeah, so these anti-slap statutes are important, especially for what we're doing, to understand that they exist, to understand what they require. And, along those veins, if you're making content, doing stuff like that, just one, don't ever intentionally publish false stuff. Do as much research as you can. Feel good in the truth of what you're saying. And three, just remain amenable that if you're wrong, to potentially correct it and be okay with it. And you that can make you hard to sue for defamation, right? With these anti-slap statutes. So that's kind of three things that you can do no matter what that can help protect you against defamation lawsuits. Elena, what is the advantage of not directly quoting him? It makes them look shady and they'll have to provide specifics in a case, right? How can he cure what they're accusing him of without specific? No, exactly what you said. As I pointed out just a second ago, it's without the specifics, you can't really technically cure it. They would have a very hard time because yes, when you go to court, absolutely. Yeah. If you file a lawsuit and there's not enough detail in the complaint for the judge or the court to really understand what it is you're suing on, well, then that can be dismissed, right? Failure to state a claim upon which relief can be granted. So yes, if they went to file a lawsuit, they would have to very succinctly state what it was that was said, it's defamatory, and what damages were caused because of that defamatory content. And Rolls, thank you. You're doing a great job. Close to 500 subscribers already. Nice. Yeah, man. Thank you. It's been great. I'm very blessed and honored. To date, my subscribers have been incredible, with just very endearing comments, very heartwarming. It's like every time I open up the app to check comments, I look forward to it. I want to go check comments because it makes me feel good. So thank y'all. Do you think they threw this together without much time researching it, or is this an actual tactic they're using? Yeah, and you are asking me to speculate, and that's okay. I am speculating right now. Do I think they threw it together without much time researching it? I'll say this is, defamation law is, like I said, it can be dense, it can be difficult, and it's very nuanced. And so normally in the legal field, in the legal industry, there's usually very specific attorneys that specialize in things like this. For me, my career has largely been evolved around the First Amendment. So I'm generally competent in First Amendment matters, which is why like defamation's okay with me. But not your average everyday lawyer is going to be super up to speed or up to par with current defamation law. So did they research it enough? I don't know. I can say this is that when you have an Indiana lawyer sending a demand letter in Arizona, which you shouldn't do, technically that's practicing law in Arizona. Well, but he might not have understood what the Arizona slap statute requires. And don't get me lying, I don't either. But maybe perhaps he didn't understand that. It seems to me that this might not be a lawyer that's necessarily well trained on defamation, and that might be why he failed, or the person failed to adequately describe, in my opinion, adequately describe the statements that were defamatory and why. But as Barron said on his live, the guy really was out of line because, look, you can write a letter notifying a party of a claim as an out-of-state attorney, but when you go to the point of saying, oh, if you don't do this, then we're going to file a lawsuit, that's practicing law in another state, and that's where he crossed the line, as Barron pointed out. Why? And so let me get back to your question real quick. It's like, so why do I think they did this? I mean, really just to scare people, I do believe. I think it was, again, just my opinion, and this is just purely speculation. I certainly don't know this as a fact, but probably just as a scare tactic, because look, we don't know what all they got going on there. We don't, because there's a lot of internal documents and contracts, things of that nature that we have that we would need to really come to some hard conclusions on a lot of the more, defamatory, the more damaging type conclusions of fraud, things of that nature. So, if they're actually engaged in stuff like that, and I know I said this on another stream and probably on one of my videos, but it's like, if discovery gets opened up, so it would be their duty to prove falsity. Okay. So they would have to prove that what Wolves and Finance said was false. So in order to do that, they would have to pull out the documents and stuff that we've been asking for quite some time to do that. So it's very interesting to think, well, if they don't file suit, again, this is just speculation, pure speculation, hypothetical theories. In a hypothetical situation, it might be okay to assume that if they don't file suit, that might mean that they don't have the evidence needed to prove what Wolves and Finance said was false. This is just speculation. I don't know that for sure. So again, and that kind of factors into what, why they're doing this. But ultimately, I'm going to rest on my opinion, pure speculation, hypothetical, being that this was just simply a scare tactic, and was, him going online and announcing it to all the world on YouTube was exactly what they wanted to do. Now, again, my opinion, speculation, what I don't think that they accounted for was people in the community being willing to step up and support Wolves and Finance, that there were some of us content creators out here who do know what we're talking about with defamation law and stuff like that, and ready and willing to educate the public here and show up and support Wolves and Finance if need be. So I don't think it's gone how they were maybe intending it. And again, this is speculation. I don't know this, but it seems to me like this might have been one of those instances, like a hypothetical scenario where someone goes and wants their lawyer to do something, but the lawyer's like, I don't know if that's the greatest idea, to do that, but they just insist. And sometimes those happen. And, us lawyers have duties to like figure out whether that's actually something that we should actually do. Sometimes we have to step away and say, we can't do that. But I think it might have been something that this lawyer could potentially have reservations about, but just got pushed into doing it. I don't know. It's just speculation. But, at the end of the day, I just encourage everyone just to be ready to support Wolves in Finance, and just understand, kind of these points in defamation law I'm discussing. So that way, moving forward, we can adjust our conduct in a way to make it less likely that these things would happen again, to give them an opportunity to have a basis to even write a letter like that. You think I'm right? It has to be for purpose of intimidation. They don't really want Wolves in Finance to have subpoena power. That's probably right. You're probably right. I mean, like I said on my video the other day, I mean, just off the top of my head, I can think of about 10 to 20 discovery requests I would like to send, that I think would be pretty powerful as far as eliciting information. Seems to me with an entity as large and well-funded as TPUSA, they would have made sure that any attorney they use for anything would not make what seems to be a simple mistake as file. Yeah, that was one of my first things was like, well, why didn't they have an Arizona lawyer send this? I mean, that makes no sense to me. I get it. So just so y'all know, TPUSA is actually officially filed in Indiana. So that's like where their official corporate headquarters is. But obviously, I think most everything goes down in Arizona. So again, you have to know that they have lawyers in Arizona. Like, why didn't they have their Arizona lawyers? And it's very interesting. I don't know the answer to that. Maybe perhaps an Arizona lawyer told them they wouldn't do it, and that was the only lawyer that they could find to actually do it. I don't know. But it is strange that they would have an Indiana lawyer send a demand letter across state lines to Arizona. So, yeah. A state they don't practice. And he goes, keep saying that. My opinion and speculation, it keeps the letters from your mailbox. So we'll talk about that in a second, because right now, in all fairness, I did say that, simply saying this is my opinion, stuff like that, doesn't necessarily escape a defamation claim. And so we'll jump into that in just a second, just so we can kind of sort that out. But yeah, now it does help. Ultimately what the court's going to look at is what a reasonable listener in the audience, perceived. And so as long as the audience isn't perceiving that you're stating, for instance, like with Wolves in Finance, like, I don't think anybody really took what he said as like 100% proof without a doubt that these people are committing fraud. I think everybody understood that he was reporting factual information. And then, like, even in the video, he's just kind of saying like, hey, based upon what, we're looking at here, it's, for me, opinion looks to be fraudulent, or there's definitely some serious questions here. So again, we'll sort that out here in just a second. I do think larger channels can often underestimate small creators' knowledge and influence. Probably so. Yeah. I mean, probably so. And I think TPUSA, just in, my opinion, I think they underestimated, how tight-knit the community actually is, and the fact that even if we don't align or agree with each other 100%, even people on both sides are really aligned on seeing this through for truth and justice. Nothing has gone the way they intended, it seems. They thought we would give this a few days worth of attention after Charlie died and then move on. They're wrong. Yeah, I think they did greatly underestimate how this was going to go. I mean, and I'll do another live stream talk about this sometime, because it's just incredible to me in this day and age, with as many people that were filming out there that day, in this day and time with social media and stuff, like, carrying out a public thing like that is ballsy. I mean, it's just ballsy. And I think we're seeing now that things didn't go, like you say, as they intended. And now we're seeing the, damage control, and, that damage control is egregious, like covering over the, paving over where this happened at, stuff like that. We're looking at, filing a notice of a speedy trial as a victim representative. So yeah, we're just seeing a lot of this error correction is almost as egregious as the original instance in some ways, right? So I hate it, and here we are. But it's super important. And one of the reasons why I jumped on to YouTube on this topic is just there's so much here to educate the public, to point out to the public of what has gone wrong. in many ways with this country, with a lot of things. And so, again, that's kind of why we're here today, too. Just kind of reading the comments, really enjoying your content, hearing things about the legality of these subjects is needed. Oh, thank y'all very much. Yeah. And, I'll say this caveat too, is that these are just, y'all are probably aware, law is gray. It's not a black and white thing. Express my opinions on the law. Barron, I think the other night, who also has nonprofit experience, had a little bit different perspective or take on some of these issues with TPUSA compliance. So, yeah. So just so as long y'all understand that, is that this is all my opinion based upon, and I try to bring everything that forms the basis of my opinion to you or state it to you. But they can vary. But like today, I'm just giving you some concepts to think about that will give you, it's not going to be, oh, this for sure was defamatory or this or that, but just some concepts to think about in the future in regards to defamation, and mostly about what kind of plaintiff is this, a public figure, a public official? What are matters of public concern? Because at the end of the day, regardless of whether you make a defamatory statement or not, as we'll see with like public figures, things of that, like the burden that they have to prove that like you had reckless disregard for the truth, or like you knew it was true, it's a very high burden. So like even if things that you state accidentally come out and are defamatory, unless you had some real specific bad intentions with that, they're probably not going to be able to prove their case. Okay. So anyways, I hope we're kind of at a good spot now. Again, it's my first live. So anyways, let's keep going. So what is an actionable statement? For that, I did some bullets here. And again, if anybody wants this outline, I put my email in the description. Feel free to reach out because I don't have screen share right now. I'm still working on integrating OBS. But I do have this outline. I'll be glad to send it to anybody who asks. But so let's talk about what is an actionable statement under defamation. But before we do that, I'm going to talk about what are the elements of a defamation claim. Okay, so meaning what does a person who wants to sue another for defamation, what do they need to prove? Okay, and so these elements came out of my Texas Forms book, but because of the constitutionality in the defamation paradigm, these are going to be pretty much the same state to state. So let's talk about it real quick. So you have to have the defendant publish a statement of fact, that statement of fact referred to the plaintiff, that the statement was defamatory, that the statement was false. And so we'll talk too is that pretty much 90% of the cases, the plaintiff, so in this instance, TPUSA, would have the burden to prove that what, for instance, Wools and Finance said was false. And Wools and Finance will always have truth as a defense. So in that scenario, if there's a lawsuit going on and we're talking about discovery, Wools and Finance is going to be asking for documents to try to prove what he said was true. TPUSA is going to be trying to produce documents to prove what Wools and Finance said was false. So you kind of have like that double effort really at the same thing. And so it would be right. So it would be extremely interesting to see the discovery process in a lawsuit between TPUSA and Wools and Finance. I mean, I could probably do live commentary just about the document exchange back and forth and stuff like that. It would be fun. I say it'd be funny. It wouldn't be funny, but it would definitely be informative and educational. Let's see. Been busy, but is Zach doing okay? Who you referring to? Is Zach Peter? Is Zach Wools and Finance? As far as I understand, yeah, I think he's fine. From in the grapevine, I think people have been in contact. I think he's got an attorney that's ready and willing to help in case of an emergency, things of that nature. How does discovery come into what you're talking about? So discovery, right, is the process in the lawsuit where we're trying to get documents, you're asking questions. This includes depositions, requests for admissions and stuff. And so in this instance, in the defamation claim, right, we've all been kind of looking at and investigating TPUSA for, again, were allegations, stuff people have it in their mind that potentially there's fraud, things like that. And so the discovery process, if there's a lawsuit, would open it up to where Wools and Finance would have a legal right to ask for documents that we don't otherwise have access or a legal right to access right now, including board minutes, contracts, things of that nature. And so that's why we've been talking about the discovery, because if it went to discovery, it would be an opportunity for the community via Zach to really pull documents and other things that could help our investigation, help what we're covering here on YouTube. So discovery is just the process in litigation and lawsuits where parties ask each other for evidence, whether it's statements, questions, physical evidence, stuff like that. It basically is where we would have a legal right, where Zach and Rules and Finance in that hypothetical situation would have a legal right to ask for those documents. And so that's why it's kind of material to our discussion here, because of the larger investigation that's going on with TPUSA. Would we get to see what he finds in discovery? I mean, theoretically, yeah. So discovery generally isn't published in the public record, but that doesn't mean that it's not protected from disclosure. So unless a judge in a lawsuit placed a specific seal or some type of discovery order preventing any of those things that are exchanged in discovery from being disclosed, then no. And ultimately, regardless, is even if Zach was not able to disclose things he learned in discovery during the pendency, towards the end, whenever they file their motions, whenever Zach would file a motion saying, hey, they don't have a claim because XYZ documents prove that they were, committing fraud. That's all hypothetical. I'm not saying they're fraud, but that's just a hypothetical situation where that could definitely occur. So we definitely could potentially see what Zach finds in discovery, and without a question, if it goes to trial and those things are produced into the court record publicly, we would definitely see them then. But when discovery occurs and documents are exchanged, it doesn't automatically go into the public record. And whether Zach could disclose those things to us would depend on several different things. But either way, obviously, if Zach's doing discovery stuff like that, we at least in a roundabout way would know what's being discovered, things like that, as we see the lawsuit progress, right? Because if Zach didn't uncover anything that indicated fraud, well, then he would end up losing the lawsuit, theoretically. Again, that's all hypothetical, not legal advice, not stating anything definite or factual about TPUSA or anybody. Do I know Baron? Depots? Yeah. So depositions, again, so deposition is just pre-trial, the ability for one party to go and question an individual, like either the other party, one of their employees, something like that. So it's basically pre-trial, direct or cross-examination. It usually happens in an office with a court reporter. Lawyers show up. The rules of evidence are pretty relaxed, and so it's pretty free range on what you can ask, stuff like that. So yeah, I don't know Baron personally. I get, through his content, familiar with him. I did send him an email or two, like right when I first started watching his stuff. There were a couple things I'd found along the investigation. I've never heard from him or spoken with him. I'd love to. I can tell just by his demeanor and content, he's probably a very good lawyer. Baron is, just my impression. I'm late. Been watching the weather here in the DMV. Yeah, we're here too. We're in the East Coast in the mountains, and just kind of hoping to stay warm and stay alive here. It doesn't look so bad right now. I think the electricity should be good. I think I should be able to make it through this live stream, which is really lasting much longer than I was thinking, but it's okay. I'm good here. I really enjoy this, especially answering questions from the comments. Zach should get Justin Baldoni's lawyer. They've just crushed the opposition with Discovery. Okay, I don't know who. I'll look into that. Justin Baldoni's lawyer. Sorry, I'm gonna write this down. Yeah, like I say, defamation's kind of a niche area of law. It's very nuanced. And so really, if you're going to hire a lawyer for a defamation case, try to get a specific one, because again, there's a lot of nuance to stuff. And when you got an area of law with a lot of nuance, you really want someone who specializes in it, because it can get real hairy real quick. And so the religious work I do, I mostly specialize in freedom of religion, protecting free exercise. it's very niche. There's not a lot of lawyers that really specialize in it. And why is that? Well, there's a lot of nuance to it. Really, any constitutional law is going to be pretty well nuanced. They would probably say a lot of things are trade secrets or get it to be attorney's eyes only. Yeah, so they could do that, right? So what they would do, I'm sure what they would probably do is before discovery starts, file a motion seeking to protect or have some type of discovery order preventing disclosure of either specific items or all of it. So there's just a lot of different ways that could go. But I would suspect they would try to protect the discovery from disclosure preemptively. It would be amazing to see information we've been wondering about. Tyler Boyer is quaking in fear. Barron really opened my eyes a bit last night with his live stream talking about, the evolution of TPUSA, and it really jives with some of the stuff I've researched and found, which I'll be presenting. But yeah, my research has indicated that, TPUSA, when Charlie started it, was really one thing, and that over time, especially when Erica jumped in, again, just my opinion, from watching stuff, things change in a material way and in a way that's not good for us, not good for the country, in my opinion. And I'll do content talking about that. It has nothing to do with the fact that, it was conservative or religious stuff like that, but just I'll show you why I'm talking about a lot of stuff they're doing was very destructive for our country, unfortunately, ladies and gentlemen, again, in my opinion. But I'll definitely reveal what I'm talking about. I'm in Western North Carolina. Me too. Just starting here. I hope we have keep electricity. Yeah, me too, love. I'm in the Nantahala National Forest. Oh my goodness, Justin Baldwin and Blake Lively case has so many parallels to this, including CIA connections. Sweet, I've got it written down. I'm definitely going to go look into that either tonight or tomorrow, and we'll report back. Thank you for that, Elena. And I hope you stay safe here in the mountains here. So TPSA would know they're opening themselves up to risk by entering into a case of discovery. Potentially, yeah. I mean, I would hope they would think that. I hope they'd know that. I hope they got a lawyer that would tell them, hey, if we file this lawsuit, we'll be opening up a can of worms. So just understand that before we do. So yeah. Let's see. Oh, Scotland peeps. Lizard, what's up, man? Baron is ace, man. From Scotland. Yeah, and I've got people from Denmark, Australia, all over Europe, stuff like that. So that's been pretty fun so far, getting people from all over the country. I mean, I hate that y'all have to watch, pardon my language, the shit show, which we're currently having to suffer through here. But, I do have faith that we're going to be able to pull it together. I think despite as crazy as things seem, I think that it's actually really bringing us together. And again, you wouldn't know that from the mainstream media, but I do. I feel that this is really bringing people together. And despite what they intended, that people are starting to really put that left versus right, liberal, conservative to the side, in understanding that, we need to put that down for a minute till we can get some politicians in office that are actual public servants and moral people, like real moral people, not just saying they're Christian or whatever moral, authority that they cling to, but like actually living what that authority requires. Let's see. Yeah, thank y'all. I appreciate it. Yeah, so let me kind of get back to where we were. So again, I read so real quick, I was going through the elements here. So we had, the statement has to be defamatory, it has to be false, and then let's talk about falsity. So with regard to the truth of the statement, okay, so this is what would TPUSA generally have to prove in a defamation claim? They'd have to show that Wolves and Finance published some statement of fact, and we'll talk about that in a second, that it referred to them, that it was defamatory, that it was false, and that with regard to the truth of the statement, Wolves and Finance either acted with actual malice, that he was negligent in regards to the truth, and we'll sort these out in a minute, or in some instances, there's actually strict liability for defamation. And those are very rare, and maybe not all states even have that, but they do in Texas, but very rare. And we're not in the strict liability case either. Okay. And then lastly, they would have to show proximate cause or damages. They would have to show, hey, this statement caused these damages, right? And then that gets into, well, if it's your reputation that was damaged, obviously there's not like a number on reputation where we can gauge how big of a hit your reputation took. But if it's a business, things like that, you could show tax returns, lost wages, things of that nature. In some cases, damages are presumed. Now, it's not going to be these cases that we're going to be talking about today, but you got to understand what I'm saying is that, you know, you have to prove damages. You have to prove that this statement caused the damages. So in the instance of Wolves in Finance, so, you know, he's not the only person out there that's made similar videos, published similar videos with similar factual statements, conclusions, stuff like that. So if they were to go to trial, potentially, if TPUSA doesn't add in everyone who's made a similar statement to that effect, or if Wolves in Finance doesn't try to add some of those people too, you know, the damage thing could get really quirky, right? Because if they're saying, hey, Wolves in Finance caused these damages, but there's been other content creators making same substantially similar remarks, well, how do you know it's fairly attributable to Wolves in Finance? So again, I'm not going to go down that rabbit hole and start sorting all that out here for you, but just to understand that it can get real hairy real quick. These are not straightforward claims and can be very difficult to prove. And so just wanted to highlight that, especially in an environment like this, where you have so many different content creators. You know, this isn't like it used to be where you have just like NBC, ABC, CBS, you know, making all the, you know, statements that make it to millions of people. Now you got a lot of people who make statements and make it to that many people. And so would it, you know, make a defamation claim much more difficult? I tend to think so. I tend to think so. I'm not going to work that out here conceptually, but I just wanted to put that on your mind to understand that that's also something that we need to consider, is just the ubiquity of stuff being published about TPUSA in the same vein as exactly what Wolves in Finance has been saying. And then you get also too, right, republishing. Was it Wolves in Finance video that caused it, or was it someone that republished Wolves in Finance content? It can get hairy very quick in this, especially in this specific climate. So let's go next. So yeah, so what we're really going to look at now is what is in so let's say it has to be a statement of fact. What constitutes a statement of fact? Because so right, and this is going to be the Milkovich, is a U.S. Supreme Court decision from 1990, but they said, you know, a statement is only actionable if it asserts or implies, okay, also implies objectively verifiable facts that are false and defamatory. So the implication is important for this reason, right? Because if you can imply an assertion of an objectively verifiable fact, that means that if you say, oh, Jones is a liar, or it's my opinion Jones is a liar, well, you're still implying that there's some type of factual basis for your opinion. Okay, so that could still potentially be actionable. There is no fact versus opinion dichotomy. An opinion, like any other statement, can be actionable in defamation if it expressly or impliedly asserts facts that can be objectively verifiable. And so let me just stop right real quick and say, you understand now that, like, does a statement imply verifiable facts? Things, it can get very dense on the analysis in defamation claims. Okay. And that's why I'm not going to stop and go through all these different claims from like TPUSA. Well, for one, we don't know specifically what some of them even are. But two, it would just be we could sit here and do hypotheticals all damn day. It'd still be just as confused at the at the end as we were at the beginning. So let's see. Let's do some comments. We are rooting for you from all the way across the water for sure. Thank you. So can a person reply to a cease and desist with a simple fuck off? Oh, absolutely they can. I mean, yeah, you can. Now, granted, that might, you know, prompt them to sue you. But you certainly can respond to that any which way you know your heart very well pleases. Let's see. South African living in Scotland. That's what's up. Broggentil, give it a few months. You'll be flying. You'll get 10K followers real quick. Well, I hope. So yeah, it's like, wow. So there's a lot you need to prove. Yeah, they're very difficult cases. They are. Especially when it gets so, and we'll learn in just a minute about, matter of public concern, public official figure, uh, plaintiffs, it gets really, really difficult. Okay. And that's really the saving grace here, as we'll learn, is that because TPUSA, for these purposes at least, is at the very least a limited purpose public figure, and and again, we'll talk about how I get there, and because, the issue with TPUSA as a nonprofit having potential financial issues, is a matter of public concern, as well as any, circumstances surrounding Charlie Kirk's unaliving. That's what really makes it difficult for TPUSA, as we'll learn in a second. But back to, about the actual statement itself. And this is what I said just a second ago. The statement, in my opinion, Jones is a liar, implies knowledge of facts that lead to the conclusion that Jones is a liar. So that, again, very well could be an actionable statement. Simply couching a statement in terms of opinion does not dispel this implication. So how does the court determine whether a statement is objectively verifiable as fact, as a matter of law? They look at least in Texas, so this point right here, this is what Texas courts generally look at. Again, I would suspect that this would be very similar to what most other state courts look at, but just want to give that caveat here. But what do Texas courts look at to determine whether a statement is either asserts or implies an objectively verifiable fact? They look at the factual setting in which the statement was made, a political, social, or scientific debate. And the reason for that is that some contexts lend themselves to people playing around or joking or not taking people as seriously as others, right? If we're hanging out on the back deck by the pool, talking is going to be a little bit different context than if I'm at the, Democratic National Convention or something like that, giving statements, right? So they look at the context. They look at the format in which the statement appears. So an editorial, blog post, website, newspaper, telephone conversation, Zoom meeting, live stream, that matters. The general tenor of the entire work. So for Wolves in Finance, they wouldn't just look at and I said this on a live stream the other day with Mr. Let Go and Danks. They wouldn't look just at the thumbnail where it says fraud with the question mark. They would look at the entire video and look at the gist and say, what would the average reasonable listener or viewer take away from this video? And then that kind of sets the last one, the reasonable expectations of the audience in that particular situation. Would they expect this person stating straight up facts to them? Would they expect, like in, Wolves in Finance video, that, hey, he's saying facts, but like ultimately, what he's saying with regards to frauds, really just his interpretation of it. So again, they look at what the average reader, listener, viewer would be taking away from the entire work. Courts look to determine whether a reasonable listener or viewer could have concluded the statements were conveying facts about the plaintiff, and then whether the statement is actually injurious to the reputation. Let's see real quick. I'm going to read real quick, ladies and gentlemen, just real briefly from the book here. It explains it a little bit more because I don't want to just leave kind of haphazard this thing of what is an actionable statement. So let me just read some of this real quick. And some of it I've already covered here, but it adds a little bit. But they say the test, so, looking to see where it's either impliedly or expressly asserts a verifiable fact. It supplants the former analysis. So there used to be a distinction between fact and opinion. But like I said, in this Milkovich case in 1990, the Supreme Court did away with it and said that, this whole opinion thing doesn't necessarily protect you if it implies certain facts. Let's see. Just a second. If the speaker states the facts, okay, on which she bases her opinion, and those facts are either incorrect or incomplete, or her assessment of them is erroneous, the statement very well may still imply a false assertion of fact. Simply couching terms a statement in terms of opinion does not dispel this implication. Let's see. Implication. Thus, whether a statement is actual in defamation does not depend on whether the statement can be categorized as opinion or fact, but on whether the statement can be categorized as fact or non-fact. The court determines whether the statement is objectively verifiable as fact as a matter of law. So again, not open and shut case, ladies and gentlemen. I guess that's one of the main things I want everyone to take away from this. I'm not going to get super dense into the weeds here. But just understand that just saying it's your opinion, stuff like that, does not shield you necessarily from defamation action. And so it can still imply an assertion of underlying facts. Okay, so that's the main thing I want everybody to understand, is that the allegedly, this is my opinion, stuff like that does not necessarily get you into the safe zone. I'm not going to speculate here because there's so nuanced. What would you do instead, or what could you say instead? Again, because it is highly nuanced, it's very situationally dependent. And so therefore I don't want to go into that speculation. If people absolutely want to learn and dive deeper into that per se, just shoot me an email. I can shoot you some materials and stuff like that. Definitely read up. Maybe we can even have a conversation about it. But I'm not going to go super deep into the speculation or tell people do this, don't do that in these regards, because I don't want people to get emboldened or brazen to do stuff that would be stupid. So anyways, sorry about that, but I'm going to leave that there. Certainly I can speak with people, or if there's a large public outcry to know more, I could do another live stream or video and go a little bit further into it, but I'm going to leave that one there for right now. So thank y'all. Yeah. And again, it gets difficult and dense too. Y'all don't want to sit here and exercise your brain like that today. Trust me. So now we're going to transition into the next, and this is really more important anyways for talking about TPUSA and defamation, is what is a matter of public concern and why does that matter? So I'll say one real quick, and it might, this might already kind of register with you, but the First Amendment is intended to protect a marketplace of ideas. And, so that way our government, our society can advance forward, presumably the best way possible, right? And so the theory being that the more ideas that we have in this marketplace of ideas, and specifically in certain categories. So again, speech has certain value to it, right? So it's like me talking about what Kim Kardashian, what kind of eyeliner she used today, is much less of a matter of public concern than did TPUSA, do something fraudulent as a publicly subsidized nonprofit. Okay. And so on the spectrum of First Amendment, someone speaking about the TPUSA thing is going to be more likely to have protection, be protected from a defamation suit, than someone talking about something like Kim Kardashian's eyeliner. Okay. And that's, for some people, this is important. I get it. But we're talking about what's a matter of public concern, meaning the overall general public. What level of concern is a subject matter to them will be a factor to consider in the level of protection given to the speaker in making the statement. Okay. Our First Amendment protects matters of public concern much more vigorously than it does matters which we tend to think are senseless or brainless. Okay. That makes sense. I'm going to check comments real quick now. We've kind of segued. Do you think give a chance to do they have to give you a chance? Yeah. So Lizard. Yeah. And so that's what I was talking about with the anti-SLAPP statutes, is that in most states under those laws, the plaintiff, like TPUSA, has to give the person that they intend to sue, they have to first give them an opportunity. They have to notify them. They have to specifically tell them, here's the statements you made, here's why they're defamatory, here's the damage you've caused. But it has to give them a grace period, usually 30 to 60 days, to either correct either correct or edit it, or give an apology or retract. And so if they don't, most state laws say that if you don't do that, and then some say you can't even file the lawsuit, some say that you can't collect damages. But in any instance, you're not going to have a successful defamation lawsuit in most states unless you give appropriate cease and desist notice prior to filing suit. I hope that helped. TPUSA push forward. Then could Zach get access to Tyler? That's a very good question. It would just depend on how that litigation plays out. Obviously, Zach's lawyer would need to make an argument as to why Tyler Boyer, Rob McCoy, or these other financials are relevant to the analysis, to his defense. I'm not going to go into that argument potentially here because we don't have everything we would need to really fully assess it. But yes, that definitely the argument could be made, and it would be up to the court to determine whether that's valid or not. And how about receipts or donors like Olympic Media LLC to make sure they receive funds and where they went? So yeah, again, that's along the same lines. If Zach's lawyer in this hypothetical could make the argument to the court why that's relevant and essential for his defense, then yeah, absolutely, you could potentially get access to it. Now, it would be harder in the sense that because Rob McCoy, Tyler, and them aren't necessarily a party to the suit, you would have to have like a subpoena, stuff like that. You wouldn't be entitled to that as a matter of right because of the discovery. More than likely, you would need to file a separate motion, get a subpoena and stuff like that. So it would not nearly be as straightforward as just getting documents from TPUSA, but it is within the realm of possibilities that possibly those could be acquired and part of the record. Aloha from Hawaii, sending warm wishes to everyone faces severe winter weather on the mainland. Here, the Kona winds are keeping things warm, pleasant 78 degrees. Oh man, that sounds incredible. Man, yeah, here it's starting to snow a bit harder and cool down for sure. Let's see. Stacy Sheridan. Speaking with Danks, my understanding is that she ran a fundraising company and then was like keeping a percentage of all the like donations incoming. And so Danks had pulled some information to suggest that was kind of strange in terms of normal, what would you say, like industry standard. It's like the rate they were taking, this seems to be a bit, again, this is just allegedly, it seems that the rate they were taking was above industry standards. So there looks to be potentially some things there to definitely be investigated. I'll just leave it at that. And so could that potentially be part of the, those documents? Well, certainly internal documents that TPUSA has related to the Stacey Sheraton deal would be fair game. But like documents from that company, their side of it could be discoverable. Again, it's just all situational. So that could be, part of it. Thank you for the congratulations, Lizard. I do appreciate it, man. Yeah, brother. I'll probably, this is really going good for me. I really like this. So I'll probably be doing lives more often, to be quite honest with y'all. I like to have a more full format. And until I get my equipment and podcast studio set up to record longer videos, yeah, I'll probably be doing more lives. Yeah. So, here we go. Yeah. Elena. Yeah. 73%. She goes, it's not a regular amount. And she's not on their tax records as being employee, even though she still works there. Very strange. Yeah. So again, those things on their face aren't necessarily like, hey, that's fraud, blah, blah. But it's certainly for those professionals for sure, like Zach and me and, Baron, these professionals, like we definitely look at that. So we would love to see some more stuff. We definitely would. And, Wolves and Finance litigation might be the opportunity to grab some of that stuff. Back to what is a matter of public concern. So the statement can be fairly considered as relating to any matter of political, social, or other concern to the community. And this is Snyder versus Helps, 2011 Supreme Court decision. Determine whether a statement involves a matter of public concern. The content, form, and context of the statement must be analyzed, including, just like it is with, was this an assertion of fact? They look at the full context. Same thing with matter of public concern. We look at the context, including what was said, who said it, and where it was said. So as a matter, so public concern, well, what is private concern? Well, a matter is of purely private concern if it is solely in an individual's interest. Okay, so it's like this. The issue of whether, you swept your porch this morning is obviously purely a matter of private concern, because the resolution of it, whether you did or did not sweep your porch, really only affects you and your family, right? So very small. Whether TPUSA, a publicly subsidized entity, has been doing certain financial transactions that contravenes the tax laws, then that obviously affects all of us, right? Our tax dollars have gone to help TPUSA remain tax-free and be subsidized. And so their compliance with the tax laws and any laws really is most definitely a matter that affects all of us, even if it's just tangential.